we're going to bring Joe Marusak into our conversation. He's an attorney specializing in criminal defense and plaintiff personal injury. Welcome to OnPoint.
Hi, Deb. Hi, Barbara.
Hi, Joe.
We should say you two know each other because Barbara was one of the experts you used in a DWI case in 2019 that actually talked about auto brewery syndrome because the person charged had that syndrome. Tell us about that case, Joe.
I got a call from someone that I knew whose spouse was arrested for DWI, and I was told that although the couple had some drinks for brunch, they hadn't had any since then. But what happened was, as my client was driving home after going to the grocery store, she got a flat tire. Somebody thought that my client was driving erratically. Police stopped my client. She exhibited, according to the police officer, signs of intoxication. And they did a breathalyzer. She registered a .30, which was 3 times the legal limit. Got arrested, and by their protocol, because the blood alcohol content was so high, they had to send my client to a hospital. And my client had the hospital blood test them, and it came up a .33.
So it kept going up.
And I knew both my client and my client's spouse. And I believed them when they said, look, there's no way that my client was intoxicated. So there was really no roadmap, no legal roadmap for me to figure out what to do in this case. So I did a little computer search and came up with Barbara Cordell's name. She gave me a lot of great advice about what research articles I should look at, and then indicating that you need to get this medically diagnosed. Before I did that, I thought it would be best to see if this was in fact the case.
Yeah, so right. I mean, why wouldn't you think it was the testing equipment, right? Maybe they were testing wrong.
Exactly. Yeah. So I had my client purchase a portable breathalyzer. My client then tested every night, and it was above 2.0, and they hadn't been drinking. So I said, okay, I think we've got something here. So again, through Barbara Cordell's advice, I was able to contact Dr. Canodia outside of Columbus, Ohio. And he was a board-certified family medicine specialist. And he and his staff were fabulous. And my client had to go there a number of times, undergo a battery of extensive testing, had to be evaluated by forensic laboratories, and was able to get an affidavit from Dr. Canodia, able to get an opinion within a reasonable degree of medical certainty that my client had auto brewery syndrome. That didn't end it, because I said, I talked around in the local legal community and no one believed me. Defense lawyers didn't believe me. Judges didn't believe me. And then I said, okay, well, we're going to do a monitored testing. First, wanted to see if we could get a hospital to do this, or a clinic, and nobody would do it for insurance reasons. So I had to hire 2 nurses and a physician's assistant, and they continually monitored my client from 9 in the morning until 9 at night to make sure my client wasn't drinking. And I had to get a court order to allow me to withdraw my client's blood, store it in a refrigerator, and then take it to the forensic lab that the district attorney's office uses. My client was a 0.18% at 9 o'clock in the morning, at 6:15, 0.25%, and at 8:48 p.m., 0.37%. I had to hire a pharmacologist to explain my client and my client's spouse prepared affidavits as to how many drinks they had early afternoon. The pharmacologist said if you had those drinks, your blood level would be somewhere between a 0.01 and a 0.05, which is nowhere near the legal limit. I presented all that paperwork to the judge and asked the judge to dismiss the case in the interest of justice. The district attorney's office opposed it, but they really didn't put in any evidence to offset my medical evidence from Dr. Canodia and the pharmacologist.
Well, what could they say, right?
Right. I mean, they would have to do their own investigation, hire their own expert. They didn't want to do it. It was a misdemeanor DWI case. And so the judge ended up dismissing the case.
But there was a lot of skepticism. So, and there's still a lot of skepticism, right? So this case is dismissed. So that means there's no ruling here that could be legal precedent in other cases.
Well,
right?
He wrote a decision. But unfortunately, the DA's office did not appeal it. So there's no appellate court that has published a decision on my case. So in my case, lawyers in Western New York, they could get this decision and submit it, but it doesn't necessarily have any precedential value. In other words, a judge doesn't have to follow what this judge did. So it can help, but it can't cinch the deal.
Mm-hmm. Before we get to some of the legal implications, did your client get treatment and your client's okay now?
Yes, dietary. I'm not sure if my client got medication, but they're doing fine and keeping things under control.
Mm-hmm. So I wonder, what do you think some of the implications for auto brewery syndrome might mean for the justice system? And I think in particular, how do you make sure, because it's so new in part, how do you make sure that you don't sort of open this up to a lot of folks who don't have auto brewery syndrome, but would certainly like to say, it was my gut that did it, and I had no intent of doing this. It wasn't my intent.
Right.
So how do you make sure that's not corrupted?
Okay, so intent really doesn't apply here. What you're dealing with is what's called a strict liability statute, in the sense that if you're driving with more than 0.08 or 0.10 of blood alcohol in your system, it doesn't matter what your intent was. Fortunately, in New York, and I'm sure in other jurisdictions, you have a venue by which you can say, look, even though technically they had more than 0.08 blood alcohol, the spirit of the law is such that it's supposed to be related to a voluntary consumption of alcohol. And in this case, we don't have that. So the legal system, even though it doesn't have the best way of addressing this, most state jurisdictions have ways to dismiss it in the interest of justice. The point is, you can't fake this. I mean, I had to hire 2 separate experts to lay a foundation to provide a court with evidence. You've got to lay a forensic evidentiary foundation. That costs a lot of money.
Right.
And so, unfortunately, you're going to have indigent clients who get assigned counsel, and the assigned counsel program doesn't have those resources. And you can't prevail unless you've got the resources to get the evidence.
But you still have the problem of convincing skeptical criminal justice system, right? That doesn't move quickly.
No, it doesn't. And so in my case, what could have happened was the district attorney's office could have said, look, we think this is junk science. We want to have a pretrial hearing in order for the doctor to come in and testify in person. But they didn't do that. But if they did, then I'd have to hire and pay the doctor to come to Buffalo from Columbus, Ohio, testify, and then wait for a decision for the judge to conclude that this wasn't junk science, that it was generally accepted in the field of this particular medicine.
Mm-hmm. Barbara Cordell, I mean, do you think that this is sort of critical here in terms of working with the criminal justice system on recognizing this?
Yes, I think they're the next big group that need to be educated. And I'm doing a seminar coming up with public defenders in a couple of months. And that's really our next avenue, is to educate. We're going to continue educating the healthcare providers, but yes, the legal justice system is next.
And what do you do about the costs that Joe mentioned? You know, these astronomical costs of trying to prove that this is a real thing and not somebody just trying to get out of drinking too much.
Right. One of the things we're trying to do is set up testing centers throughout the United States that people could travel easier to, so that I may have one here in Texas. We have one in the Northeast. We're trying to get one in the Northwest. It would enable patients to travel at low cost to some of these centers to get tested.
And Joe, I wonder, for you, what do you think the broader legal implications are here?
I mean, fortunately, most courts, like I said before, have this avenue through which they can dismiss cases where this condition exists.
Mm-hmm.
But because this is so rare, you're probably not going to get any legal or political momentum to try to make this defense more affordable. And that's unfortunate. Because it's so rare, I think it would fall low on the totem pole if you wanted to make any legislative changes to the legal system.
But what about how gut microbes might be affecting other forms of behavior? Are we talking about something way down the road here?
Well, that's a good question. That's where your experts come in. Certainly this affects drinking, alcohol-related crimes, whether it can explain or mitigate behavior in other assault type of crimes, mens rea type of crimes. Now you're looking into neurologists. All right. You're not looking just into behavioral, you're looking into cognitive and neurology. And so you're going to have to get the pros and the certified practitioners in neurology to see if they can do any research. Again, it's all research driven. If you cannot get this connection accepted within each field of a particular medicine, it's not going to get into evidence. If it does happen, it's going to be years down the road because you're looking at a new area of medicine, neurology.
Well, Joe Marusak, who's an attorney in Buffalo, New York, and Barbara Cordell, who is the president of the organization Auto Brewery Syndrome Advocacy. I want to thank both of you for joining us today. I'm Deborah Becker. This is OnPoint.